afternoon.
Good afternoon, Your Honors. My name is Adam Rodriguez. I represent the plaintiff appellant in this case, Mr. Adam Thomas, and I would like to reserve 3 minutes for rebuttal.
Very good. 3 minutes.
As indicated in our brief, I understand there are two main issues that we are addressing here before the court today. I'm going to focus the majority of my time on one issue because I think the trial court was very clear that this issue was the primary reason that our case was dismissed at the trial court level. And that is the issue of whether or not constructive discharge is actionable as a matter of law under the Tennessee Public Protection Act. I also think that in addressing that, I know I will also address the dismissal question as well, but I do think that constructive discharge is the primary issue. Regarding constructive discharge, I would submit that this court has already addressed this issue, admittedly in an unpublished opinion, but has addressed this issue and has resolved in our favor. In Coffey v. City of Oak Ridge, a 2014 case before this court, in the issue statement of that opinion, the court said one of the issues was whether constructive discharge is actionable under the Tennessee Public Protection Act. When the court then analyzed that question, as the court typically does, it laid out the jurisprudence it thought relevant to that question. There's one case in particular I wanted to draw attention to, the final case that the court cites when it's setting its standard for how it's going to engage in this analysis. It looks to a case called Howard v. Life Care Centers. And it pulls a quote from that case that says, "This court has held that termination under TPPA clearly requires an act on the part of the employer to end the employment relationship." Now, having set forward that standard, the Coffey court then proceeded to engage in a factual analysis of Mr. Coffey's claims. Now, I do want to highlight that that case had been decided on summary judgment, so there were depositions and a full factual record to consider. We have not yet been given that chance because we're here at the dismissal stage. But the court goes through the facts of that case, ultimately holds, we don't think the facts rise to the level of constructive discharge.
Counsel, doesn't that become problematic for your position that we've decided this issue? I mean, essentially, isn't it not really a necessary component to determine in the Coffey case whether, in fact, constructive discharge equals termination or not? And if there's no actual constructive discharge, the court doesn't really need to have answered that question. So, and while there's language that suggests constructive discharge may be appropriate, it's not really a holding, is it?
Now, I understand, Your Honor, and again, I understand also this was an unpublished opinion, and I do understand that the Coffey court says even if constructive discharge were on this record, we don't hold that the facts rise to that level. So I understand they don't make an explicit holding on this as a matter of law, but I also understand that they don't expressly hold that it is categorically not available under the Tennessee Public Protection Act. And that's the primary issue here because the trial court took this language from Howard, the act language, and then use that to say the act of the employer has to mean.
Is it fair then to say, thinking about the different cases that you and opposing counsel cited, that we really have an unsettled question of law in Tennessee? And there's language with regard to act suggesting, and perhaps it means more in terms of actual termination, or language that you reference in Coffey, but really we don't have a case that definitively settles this, do we?
Yes, and I would acknowledge that, Your Honor, and partially with that, again, that this was an unpublished opinion. So if anything, I know it's persuasive and the court hasn't expressly held, and in this case, they didn't directly say, as a matter of law, this is available, but they left the question open. And I would say, based on the question being open, if anything, all we're asking is that this court would do what the Coffey court did in that case, is they considered the facts. And then they said it wasn't constructive discharge. We're just asking that it be considered a factual question and not purely a question of law. And that even if we're going to consider the question of law even if we're going to focus on the Howard language, on this act language, as I contested at the trial court level, I still would say that our case meets that. But long form to your question, Your Honor, yes, I do think there is still ambiguity on a published holding on this exact issue. But at the trial court, so the trial court made it very clear, we think the act of the employer means the employer has to terminate. And the employer has to be the final actor concluding the employment of the employee. And that, even on a record like ours, in which my client was told, you can resign or I can fire you, and then when my client said, I guess I'll resign, okay, then make your resignation effective immediately. And so even in that scenario, the trial court held that is not an act of the employer under Howard. I submitted, Your Honor, that's an ultimatum. And I would say that this ultimatum from the employer saying you can resign or I can fire you absolutely should qualify as an act of the employer that would result in the termination of my client. And the trial court said, plaintiff has a good argument, but I don't believe that's an act. Now the Court of Appeals may differ. And of course, we're here hoping that the Court of Appeals differs on that issue.
Counsel, has the Tennessee Supreme Court answered the act aspect of this through its Lemon decision? I'm thinking here of this language in Lemon v. Williamson County where constructive discharge takes place when the conduct of an employer effectively forces an employee to resign. And if it's conduct that's effectively forcing, isn't that an act?
Yes, Your Honor. I would say it is, and I did want to draw attention to the Lemon decision because the conduct of the employer in this case was giving my client an ultimatum. You can resign or I can fire you. It's up to you, but your employment's going to end. And that, I think, right around the same quote that Your Honor is referring to in the Lemon decision, when they explicate a little bit more of what the purpose of constructive discharge is, the Lemon court says it recognizes that some resignations are coerced and that employers should not be permitted to escape liability simply because they forced an employee to resign. And I would say that's precisely what happened in this case, is that my client was forced to resign and that amounts to a constructive discharge, and that this is the exact scenario that the Lemon court is hoping to avoid. That because if this were allowed, I think the public policy implications are really negative for the public, because then an employer would know if I just force an employee to resign, if I give them an ultimatum and I can get them to resign, then I escape all liability under the Tennessee Public Protection Act.
But what is the coercion element here? I mean, the employer offered a choice, termination or resign. Your client seemed to think, well, I don't want a termination on my record, but that's not coercion on the part of the employer.
I would submit, Your Honor, that, I mean, he's still being coerced to end his employment. He does not have a choice.
Well, it's going to end one way or the other under
Correct.
both options, of course. But he made his own judgment, though, resignation would look better for my record. It wasn't the employer saying, you know, I'm not going to accept anything other than a resignation. That's how we have to do it. He was given a choice, termination or resignation.
I understand that. I would say it's a very restricted choice because he still does not have a choice to remain. And I think the material question for resignation or termination is, a true resignation is, I can choose to stay here, and I chose to resign. He didn't have that choice. His choice was, how is my employment going to end? And so, and I think the jurisprudence on constructive discharge, and I understand that my friend has said that if you strictly interpret the statute, that language isn't there. Well, constructive discharge comes out of the Title VII world. It's also not expressly there. And I think it was created just out of an understanding that if the public policy motivation behind a statute that's supposed to protect employees from unlawful conduct of their employers, in this case whistleblowing, is to make sure that an employer doesn't violate the law and that the employer can't get around it through some kind of loophole. And we would submit that if an employer can give someone a choice if they could resign, but there's still no true choice of staying, that's not a real choice, and that gives them I just can't imagine that was the legislature's intent with the Public Protection Act, that I could give my employee an ultimatum, and if they resign instead of me firing them, that now whatever they whistleblew, whatever the illegal activity was they reported, or any of the things that they submitted, now we evade liability under the Public Protection Act. And so I also would just want to draw the court's attention to that even though there might still be some dispute about maybe the material facts of this case, we are still only at the dismissal stage. And in both the Coffey decision and another decision we cited, White versus Fort Sanders Medical Center, the court ultimately evaluated the facts, said that those cases didn't amount to constructive discharge, but both of those cases were decided at the summary judgment level. So there was a full discovery record to fully consider whether or not those facts amounted to constructive discharge. Now, I do submit that giving an ultimatum, I think, is a persuasive fact, but even beyond that, if we had the opportunity to go through discovery, I think that gives us more grounds to try to establish whether or not there was constructive discharge here and not to be preliminarily dismissed.
On that thought, what material fact do you contemplate discovering through the discovery process that's not available in this record already?
Well, if anything, I think that depositions of the primary chiefs who were the decision makers in my client's termination, I would just have to imagine that those depositions and those conversations could absolutely present some helpful material facts for any further information that went into their decision-making process. Obviously, as my client's attorney, I know my plaintiff's side of the story, but I don't know any further information on what this communication was. I also don't have emails internally if there was any communication amongst the supervisors about this that, of course, my client didn't have access to. But I still would submit that I do think that the conversation that we've alleged of the ultimatum conversation, and then the scheme that we put in our pleadings of the supervisors really orchestrating it so that it was impossible for my client to get coverage on February 14th, 2023. And that was a day where he goes to Arlington Cemetery to visit the grave of his fellow fallen soldier who was in his unit in Afghanistan. He goes there every year. It's one of the most, if not the most important day of the year. And long story short, we allege that the supervisors very intentionally made it so that my client could not get coverage that day. And so it was that event that then precipitated the conversation that said, we're going to have to part ways, we're going to have to fire you. And so, and the individual who their shift wasn't able to be covered, the conversations about all those conversations, I think, would be material to illustrate that there was, in terms of the intolerable working conditions analysis, that there were efforts made by the supervisors to make it intolerable, to make it practically impossible for my client to remain employed at the Nashville Fire Department.
All right.
And I will reserve my 3 minutes for rebuttal. Thank you.
All right. Thank you, Mr. Rodriguez. Good afternoon, Mr. Puckett.
Good afternoon, Your Honors. May it please the Court, my name is Benjamin Puckett, and I represent the Metropolitan Government of Nashville and Davidson County. This Court should affirm the trial court's decision for 3 reasons. First, the General Assembly chose to enact a strict and stringent standard and set a high bar for recovery under the TPPA. The act then requires an affirmative act on the part of the employer to end the employment relationship, to discharge, or to terminate. Accordingly, the trial court was correct in finding that the plaintiff had failed to state a claim. But moreover, the complaint also doesn't allege that plaintiff was required to participate in or remain silent about any illegal activity. Plaintiff's conclusion that medical transport or the involuntary taking of an inmate from the jail to the hospital is the same thing as medical treatment is just that. It's a conclusion, and this court is free to disregard it, and it should. And third, the complaint also fails to allege that plaintiff actually reported these alleged illegal activities or effectively blew the whistle by reporting to the appropriate parties or exposing it outside of the accused wrongdoers.
Counsel, does it really matter whether the transportation itself is medical treatment or not? And if later this afternoon, if I'm sitting in my office and a friend comes to me and says, I want you to drive me to the bank because I'm going to rob it, and I give him a lift, I'm not going in the building, I'm not doing anything else, am I not participating in sort of that's a broad term, participating in the bank robbery? I'm not in the building, but I'm certainly facilitating it.
Thank you, Judge Usman. I think that hypothetical sort of anticipates that the bank robbery is going to happen. And importantly here, the bank robbery never happened, right? Because the inmate was taken to the hospital. Then the inmate told the doctors and the nurses, I refuse care, and he was immediately discharged. He was not treated. And so the transport at the behest of the jail of an inmate who was experiencing high blood pressure, this is according to the complaint, sufficient to meet the terms of a medical emergency, transported from the jail to the hospital where then the inmate was able to refuse care. I don't think that it sort of maps with the bank robbery conspiracy analysis.
Going back to whether or not constructive discharge is a triggering event under the Act does use the word both termination and discharge. Do those words mean the same thing?
I think it's possible that the General Assembly was engaging in a little bit of redundancy, but I do think that discharge can connote something maybe more encompassing than a termination. A termination may be for cause, whereas a discharge could be any reason to end the employment relationship through reduction in force or some other kind of means of discharging an employee.
Well, if that's the case, then, why wouldn't discharge also encompass constructive discharge?
I think there is an answer to that, and I think that's from the Howard Life Care Center, where they say that discharge or termination element under the TPPA clearly requires an affirmative act on the part of the employer. I think reduction in force or other means of terminating or discharging an employee are.
Or would creating a hostile work environment be an act?
I think, Your Honor, what we're engaging here in is a causal chain. We're saying there was an act that then precipitated a decision by the employee. I think, Judge McBray, you hit on it a little bit earlier when you suggested that is there coercion in this case, and is a constructive discharge, which I think needs to be noted, it's a legal fiction. It's a sort of court creation. My colleague mentioned that it was derived from Title VII law. I think there's an important difference between Title VII law and the TPPA in this case. And that sort of goes to the crux of my argument here, which is the default in the state of Tennessee when it comes to lawsuits against the metropolitan government is that Metro is immune from suit. Now, of course, the General Assembly can waive that immunity, but they have to do with clear and unmistakable language, right? And it has to be sort of in the express terms of the statute. And so when this court looks at a waiver of sovereign immunity, the focus should remain on the actual words that were chosen by the General Assembly. Here, the General Assembly did not choose to include constructive discharge, which is a legal fiction for when an employee makes an affirmative decision to end his or her employment. But it's
what do we do with the language in Lemon that a constructive discharge is legally regarded as a firing rather than a resignation?
The cases that Lemon was discussing there are, I think there were contract law cases, there were anti-discrimination cases coming out of the federal court, and there was a loose reference made to the common law tort of retaliatory discharge. The three of those sort of categories of laws do not encompass the TPPA. I think the TPPA is an independent statutory regime that has to be. It
is a retaliation protection, though, right? I mean, this is. I mean, the caption alone is this is a retaliation protecting against measure.
I think that is accurate, but I do not think that it reaches the level of other encompassing retaliatory protections, such as Title VII, which includes a wide variety of adverse employment actions. Here, this is a very specific, and the Supreme Court said that this is a stringent standard and a high bar for recovery.
We also have, though, the language of Lemon, the doctrine of constructive discharge sits comfortably alongside the discrimination and retaliatory discharge statutes. It facilitates rather than frustrates the aims of those statutes. And so, and I'm looking at Lemon, and it's not an all fours case. It's not a TPPA case. I take that point, but there's a lot of language in Lemon that's telling us where it's retaliation, and even to the point of, as you know, common law background here, that constructive discharge goes along with termination in that context. And so it seems like if we adopt the position or we embrace the position the trial courts said, we're certainly creating tension with the decision reached in this case and the Lemon decision.
Well, I would suggest that because the cases that Lemon cites are common law cases, and I think it's important to note there that Metro was immune to the common law tort of retaliatory discharge. So the government could not be sued. Public employees did not have the availability to bring that kind of claim. So we're just in a different, I think we're in a different world here than the anti-discrimination statutes, than the common law retaliatory discharge laws, or even contract law. I just think that they're different, and so in that way, we're not setting up tension with Lemon.
How does the canon of construction in reading language in accord with common law understanding of the language come into play in this case? I mean, you're essentially saying that was a common law retaliation claim. Part of the court's backdrop, right, is in Lemon is that common law retaliation includes, where termination is listed, includes constructive discharge. Is the common law interpretive canon applicable in this case? Is it not applicable in this case? Why or why not?
I think to the extent that it goes too far afield from the express terms chosen by the General Assembly, that it's not applicable. I think where those terms are consistent, where the common law interpretation is consistent with the express terms chosen by the General Assembly. Because as you know, Judge Usman, the General Assembly is assumed to have known of the common law. And so if they had wanted to choose constructive discharge as a element of a claim under TPPA, they certainly were able to do that. But they didn't in this case. And I think that is decisive of the issue, particularly in light of the fact that this is a statute that's in abrogation of the common law, right? Because the common law default, again, is sovereign immunity. So when a statute is in abrogation of that, the language must be strictly construed in favor of the sovereign, in this case in favor of Metro. Plaintiff is asking you to construe it in his favor, which is just impermissible. So to the extent that there's this argument, this tension that's going back and forth, that the court's purview there, the court's job there, is to interpret that in Metro's favor. I'd like to address White v. Fort Sanders and Coffey. I think, Judge Usman, you already said on this, this is an unsettled question of law. White doesn't confront the issue. They're just simply not confronted with the issue of whether constructive discharge is actionable under the TPPA. They just sort of assume it for the sake of the argument because the parties assumed it. So because that claim wasn't brought before that issue wasn't brought before the court, the decision is not decisive. Further, in Coffey, the trial court did decide that constructive discharge is not actionable under the TPPA. Coffey acknowledges that, but never expressly overturns that decision. They just go on to say, what we have here doesn't amount to constructive discharge, and then the logical conclusion is, if it doesn't even amount to constructive discharge, then it certainly won't amount to this affirmative act on the part of an employer to end an employment relationship. So again, those two cases, I don't think they're persuasive. They're certainly not dispositive of the issue.
Turning back to the medical treatment issue, we're at the motion to dismiss stage, and opposing counsel says that it's essentially an inherent part of a paramedic transporting somebody is that there is medical treatment involved, and this individual is refusing any medical treatment. At the motion to dismiss stage, is that enough in and of itself to say that, in fact, that for purposes of considering this in terms of a motion to dismiss, that there's medical treatment here? We're assuming that back.
I apologize. No. I think I'd like to parse those two ideas, because I think there are two ideas there. I think the first one is an allegation of fact that I was ordered to transport this prisoner from the jail to the hospital. And then the second part is the legal conclusion that what I did was the same thing as medical treatment, which I'm telling you is illegal, coerced medical treatment. All of the law that we have cited by plaintiff and the regulations and the statutes talk about coerced medical treatment, forced medical treatment of an inmate who's in someone's custody. Here, we don't have any allegation that he was ordered to perform any medical treatment of this individual.
But isn't he saying that it's an inherent part of it? If I'm a paramedic and I put somebody in and I'm transporting them somewhere, I'm supposed to do certain checks, I'm supposed to engage in certain medical considerations, checking your pulse, whatever you're doing, that's an inherent part of it. So while he wasn't specifically ordered to do those things, by being ordered to transport him, he was directed to engage in that conduct.
Well, so I think there's a decision point there for him too, right? Because he's faced with an inmate who has refused medical treatment. The nurse isn't treating him at the jail. The doctors aren't treating him at the hospital. In his ambulance, he says, in his complaint, he uses the word obligated. I felt obligated, but I didn't feel ordered. I felt obligated to do this. But that was a decision point for the plaintiff. Do I decide that an inmate who has refused medical care, do I decide to engage in medical treatment anyway? I think that's a decision that's independent of what he's being ordered to do, which is transport this inmate who's experiencing a medical emergency to the hospital.
Is that an appropriate distinction to be drawn at this stage, or is that something that we need to await further development of facts? Maybe it's an issue for summary judgment as opposed to a motion to dismiss. Maybe it's, and is that something that we really can decide now? I mean, no set of facts consistent with, and can a court really pull the trigger at this stage? I mean, the trial court didn't, right? That's not the basis of the trial court's decision. And is that something that really is appropriate at this stage to pull the trigger on?
I would suggest that it is, and the reason is because these aren't muddy facts. These aren't sort of a notice pleading where it's a bare bones complaint, and really, there's a lot left to be discovered here. The complaint is verbose, and it attaches a lot of exhibits, and we know exactly what plaintiff thinks of his claim, and so we know the exact set of facts. I think what we have in front of us, and keep in mind, Your Honor, this was his second bite at the apple, right? So there was a complaint, and then Judge Binkley, the trial court, gave him an opportunity to amend. He did amend, and so we have plaintiff's thoughts on exactly what his case is, and it's in the complaint. And so I think the court can and should look at the words used in the complaint, and rather than recreating a claim that's not there, use the claims, use the allegations in that complaint and say, this either meets the standard or it doesn't. And in this case, for the reasons that I've said, I don't believe that involuntary transport of an inmate should be legally considered medical treatment by this court. I see I've run out of time, so unless the court has any more questions.
No.
Thank you very much.
Thank you, sir. Mr. Rodriguez, your rebuttal.
So the first thing I want to say in response to my friend on the other side is the TPPA is a very strict law. And that's part of why, if we categorically allow constructive discharge to just be unavailable as a matter of law, I think that's going to be extremely onerous to the public and be outside of the legislature's intent. It's a sole cause standard statute. It's already very hard to prove that, as opposed to Title VII and other discrimination laws that are either a motivating factor or a mixed motive standard. TPPA is sole cause, so you have a high bar already. And then we've also talked about all these cases that the appellate court did not find constructive discharge happened when they engaged in the factual analysis. And that's because even when you do analyze the facts, it can be really hard to meet a constructive discharge burden. And so ultimately, I think TPPA is a tough law as it is, and I think the Assembly's intention is already in the law, and adding constructive discharge is something that cannot be prevailed under. I just think makes it even more onerous than the legislature would have intended. As far as the medical transport, it's in our complaint that my client had to assess his vitals when he's in the ambulance. That is medical treatment. I mean, he took his blood pressure, he had to do all those things, and that was all against the patient's consent. I'm honestly not sure what further to say about that. I mean, and other than in terms of the discovery questions, to your question, Judge.
Is it necessary, though, to even reach that in terms of the statute participating? And the classic black letter law definition of aiding and abetting, for example, includes some level of participation in the criminal enterprise. And so, returning to my bank robber scenario, and I hope nobody shows up asking me to drive them to rob a bank later this afternoon, but aren't you participating in the crime, even if you never walk in the building? So. And I'm not trying to equate what's occurring here, but just the concept of transportation and facilitation. And do we even need to determine whether it was medical treatment, or is that enough to constitute participation just by being the one who brought him knowingly to where this treatment was going to occur against his will?
Is your question whether or not my client participated in the illegal activity and therefore
Yeah,
cannot raise it?
is the transportation on loan enough, even if it wasn't medical, is it enough to constitute participation?
Sure. I mean, I think it's an ambulance. And I think the common understanding of you're being put in an ambulance is you're undergoing medical treatment. And if they didn't want to do medical treatment, then they would have put him in the sheriff's car from the jail instead. And so I still think that there is, yes, there's a participation on the part of my client, which he then later, of course, extensively protests that he didn't think he was supposed to do this. But, and yes, at the motion to dismiss stage, I would further say to your point, Judge Usman, I do think in discovery, there's a lot of paramedic standards that my client would be able to testify to, that to his term obligation, that he'd be able to address as to why he felt I'm obligated as a paramedic to do the things that I did when I transported him. I see that I'm out of time. I don't know if the court has any further questions. If not,
Hearing none. All right. Thank you, Mr. Rodriguez and Mr. Puckett, for your arguments. We will take this matter under advisement. And I would like to compliment these attorneys. The students who are here today, this is a good example of, to show you how attorneys can effectively advocate their client's position without saying derogatory things about the other side or screaming or hollering. And so this was a wonderful representation of our profession. Thank you both.
thank you, Your Honor.
Okay. That concludes the docket, and normally the clerk would say, "All rise," and we'll walk out, but we're